Hello, I'm Adam Kielich, the principal attorney at the Kielich Law Firm in Bedford, Texas, just outside of Fort Worth, Texas. And today's short video is addressing the question whether you can have temporary orders in an uncontested divorce. The answer to that question is yes, you can have temporary orders in an uncontested divorce, but they are rare. They're extremely common within a contested divorce, but most uncontested divorces do not have temporary orders issued. Temporary orders are orders that establish a norm or maintain the status quo through the divorce process to avoid harm to the parties or the property involved in the divorce, as well as establish rules for temporary custody, temporary child support, and the like. These are permitted under the Texas Family Code for this purpose, and judges have broad discretion on the specific kind of orders that they can issue within these subjects. With regard to an uncontested divorce and requesting temporary orders, I think the biggest question to ask yourself is if you really need the court to come in and place an order after a hearing for the protection of the parties and for custody, then maybe the divorce is not really as uncontested as you think. If there's already disagreement about how the property should be dealt with, or how the possession or child support should be dealt with, then maybe the parties are not really that close, and ultimately this is going to be a contested divorce. Now, the court can order agreed temporary orders that the parties have agreed to, but I think it still raises the question why the parties even need the court to set those rules by order and then really think the parties will come to an agreement on their own afterwards. If an agreement is going to be reached, for the most part, we would expect that that agreement is going to be reached even for the conditions during the pendency of the divorce, in between the filing of the petition and the court entering the final decree of divorce. But that said, there may be some situations where temporary orders in an uncontested divorce actually do make sense. Sometimes in uncontested divorces, the parties have reached an agreement, or they're going to reach an agreement soon, but there's a sense of insecurity by one or both parties that at any moment the agreement could unravel and suddenly they won't have access to the kids or the bank account or whatever. So having those temporary orders sort of set up the rules while the agreement is being negotiated, or to make sure during that waiting period before a divorce can be ordered, that there's some sort of stability in the process to ensure that the ultimate agreement can be reached and maintained. The temporary orders can do that. They can establish that sort of status quo during the pendency of the divorce, and then the parties can fall on their agreement in the final divorce decree. Additionally, many times divorces start out with some uncertainty whether an agreement will be reached, or there's some actual conflict that's going to lead to a contested divorce. But then down the road, the parties sort of calm down and back off, and an agreement can be reached, and the divorce proceeds on those agreed terms. In that case, it may be necessary to set up those temporary orders as a way of sort of quelling the conflict and getting the parties in line to be able to reach an agreement. So in that case, the temporary orders may not only make sense, but be fruitful for the purpose of avoiding further conflict within the divorce. Additionally, they may make sense where an agreement tentatively exists, but the two parties are not really sure whether that agreement will last into the future, or maybe one person isn't so sure that this agreement is going to work. In those cases, the parties can seek to have their agreement set up as a temporary order, and sort of give it a trial basis before the final divorce decree is issued. That can be a good purpose for temporary orders where the parties have set up an order for a particular custody schedule or for child support or whatever, and they want to make sure that this situation works, and if it doesn't work, then some other agreement will have to be reached. Now, I think that still raises the question of why the parties can't simply follow their own agreement without the temporary order, but again, sometimes people feel like the agreement is more secure if there's at least some kind of court order ordering both parties to follow the agreement. In these cases, the perception of the parties may be particularly important to secure the agreement and the good faith of both parties. Outside of that, though, really, if temporary orders are involved in an uncontested divorce, I would be hesitant to really continue along the thought that this is an uncontested divorce and not a divorce that's ultimately going to lead to some sort of conflict or contested result down the road. But they are available, they can be used, they should be used very sparingly in these situations because it's just as easy to go in for a temporary orders hearing thinking both parties are going to ask the court for the same thing, and then either the court decides it doesn't want to do that, or one of the parties has a change of heart, and suddenly the case is blown open, and there's a lot of conflict out there. So they should really be used sparingly, and if they are going to be pursued in an uncontested divorce, that's really a good time for an attorney to get involved on one or both sides.